Hello everyone, this is Cheenu Sharma. Welcome to our mega answer writing session for the exam of NCA Constitutional Law. So in this lecture, I'll be firstly talking about the latest sample paper that is there on NCA website. So we will be discussing all questions. Also, will be providing the PDF so that after watching this video, you can follow the detailed answers from there and you can practice if you want, and you can also refer an examination as well. So latest sample paper solved you will be getting in this video, and then 100 marks newly self-prepared hypothetical questions for practice. So we will be taking up these 4 questions as well, and importantly legal memo. So there will be 2 questions related to legal memo. You can follow this exact pattern in examination. So I'll be discussing how you have to write recommendations, suggestions, or any important actions, solutions. So all these things will be discussed today in this video. Now let's get started. Okay, so let's start with our first question. So when you see the sample paper that has been given by NCA, so FLSC for NC examination, they have mentioned in part 1 and part 2 few questions related to statement based reasoning, true false. So in examination sometimes there are chances that you might get questions in the form of MCQs, fill in the blanks. So you have to keep yourself ready for all kind of surprises for every kind of question format. So firstly in part 1, 25 marks in total, 5 marks per question. So here it does not matter whether you are getting a 5 marks question. For constitutional law specifically, for every question you have to 100% follow the IRAC method. So here, firstly, let's read what question is asking. So in a few sentences or short paragraphs on each question, assess the accuracy. So the statement may be true, false, or somewhere in between. Like it could be half true, half false, misleading, incomplete, whatever you feel. So they are not saying that you have to give a correct true false answer. If you feel the statement is partly halfly true, you can write in your assessment partly true, partly false as well. It's just that whatever answer you are giving, you have to give a compelling reasoning. Be sure to direct your response precisely to the statement. Points will be given for supporting your answer with reference to relevant case or constitutional provisions or readings listed in court syllabus. So first statement is hospitals are bound to comply with Charter of Rights and Freedom. So sometimes we feel that hospital means some kind of public institution. So this is as per section 32 application topic. So here they are giving a significant term, are bound, some kind of compulsion, but this is not true. In every case where hospitals are not governed by some kind of public statute or some kind of authority, duty, delegation by government, or completely hospitals are private institutions or by private bodies they are being run, there the hospitals are not bound to comply charter. So only where some kind of government thing is involved, public entity is involved, only their hospitals are bound to comply with Charter of Rights and Freedom. So this statement is not partly false, this statement is partly true. It means the statement that is before us, this statement in itself is saying something correct, but there is something missing in this. So that is why we are assessing this as partly true. So the issue is whether hospitals are obligated to comply with Charter of Rights and Freedom. So as per section 32, which talks about application, it outlines that yes, charters are, but where some kind of government entity is involved. The hospital is being governed by some kind of government statute, public statute, or it has been funded by government, or there are some rules and regulations, some kind of body, commission that is working, that is taking decision on part of hospital that is governed by some kind of government authority. There is delegation of power to take action, to make rules and regulations by some government authority. So only there that hospital will have to comply with Charter of Rights and Freedom, will have to take care of people's fundamental rights. Otherwise, if it's completely private in nature, then human right commission, human right codes will apply. There you don't need to follow this charter. So this is application. Hospitals as institutions that might receive government funding provide essential public service can be considered as acting on behalf of government. Therefore, they are bound by charter. They have to comply with fundamental right like life, liberty, security. But this is important. That is why I have underlined here. If a hospital is wholly privately owned, then charter will not apply, although other human rights codes might have applicability. So for this, the landmark case is Aldridge versus British Columbia. Then in just one line, you can give your conclusion because these are short questions. Then next is the Prime Minister is Canada's head of state. So this is 5 marks question. This statement is false because when we look into section 9, this is the very first section that we cover under sources. So according to Canadian Constitution, the head of state is the monarch, His Majesty King Charles III right now, who is represented in Canada by Governor General. Section 9 of the Constitution Act 1867 states that the executive, government and authority of and over Canada is hereby declared to continue and be vested in the Queen. So from this section, we are getting the answer for this statement. So Prime Minister is head of government, not head of state. So you have to understand the difference between these two terms. The distinction lies in ceremonial symbolic roles which are performed by a monarch or governor general as head of state. So what is the conclusion? Statement is false. Prime Minister is not Canada's head of state. And this thing is mentioned. The source is the Parliament of Canada's website, which explicitly mentions that Prime Minister is the head of government. So third is straightforward question, straightforward statement. The notwithstanding clause in section 33 of Canadian Charter of Rights and Freedom enable legislature to pass law that will operate even though they conflict with other provisions. So we know that we have read this thing, but the operation limit is 5 years. So this statement is true. The issue is the purpose and effect of notwithstanding clause. So section 33 allows this thing. Then how do we apply? So whenever a legislature enacts legislature using this clause, it allows the law to remain in force even if it conflicts with specific charter rights. So we have list what all charter rights under section 33 we have already discussed in our lectures, providing a temporary exemption from constitutional scrutiny. So for a limited period. In Ford versus Quebec, Supreme Court held that the exercise of override power was adequate in a legal sense. The explicit declaration has been effectually inserted into each of the acts, coming with the omnibus description. So now, few of you might think that this statement could be stated as partly true because of the restrictions, but you have to understand when we go by the definition, then this is the wording that is mentioned there. The restrictions, everything is secondary. So even if in examination you are writing partly true, that will be right as well, but there then you have to explain further that why you are mentioning it partly true. Here, if you want to keep your analysis crisp, short, and you want to straight away give the answer looking upon this statement, then there is no need to go by those details. So fourth is provincial legislature of Manitoba, New Brunswick, Quebec are the only 3 provincial legislature subject to constitutional requirements that they pass laws in both English and French. So this statement we read under section 133. This is correct. So there is nothing confusing here. So for application, we can refer to any important one landmark case that would be more than sufficient to answer these kind of straightforward questions. Then we have aboriginal right of Métis people recognized and affirmed by Section 35 include practice, custom, tradition that were defining feature of Métis society at the time of first contact with European. So here, whenever you are getting a specific indigenous people category, then you have to firstly try to figure out whether you have read any case law related to that particular indigenous category. So here for Métis people specifically and with relation to this European contact, we have important case of R versus PBDLES. This statement is partly true. So this statement is saying that aboriginal rights of Métis people are recognized and affirmed by Section 35, which include practice, custom, tradition that were defining feature of Métis society at the time of first contact with European. So issue is the scope of aboriginal rights here under Section 35. So Métis rights under Section 35 encompass this thing. However, this interpretation and recognition of these rights may evolve through legal proceeding and negotiation. There are few limitations when we look upon these kind of aboriginal rights. So this statement is not 100% true in every situation. So R versus Pavle says that the court held that focus on European contact had to be pushed forward to Métis claimant of aboriginal right to the time of effective European control. So this is partly true. While Métis rights are recognized, the scope and content may be subject to legal interpretation and development. Why I am saying this? Because when you look into the legal interpretation of these kind of cases, it is specifically mentioned by the courts of law that for every aboriginal right, it depends upon case to case what the conclusion is. That is why we are saying this is partly true. So these were the true false. Next questions are straightforward. We just have to tell which legislative body have jurisdiction to enact a particular subject matter. So approximately 55 minutes including reading time, which legislative body have jurisdiction in each case indicate whether it is parliament alone, provincial legislature alone, or both parliament and provinces have jurisdiction to enact law that can pass law in relation to stated subject matter. Provide a brief explanation for your answer that refers to relevant heads of power in the Constitution Act 1867, any relevant case law interpreting the scope of relevant federal, provincial legislative power. So by the very wording of question, you get to know that the main focus is to decide the head of power under which particular subject matter is coming and at least one case law. So first is the terms and condition of employment of flight attendant working for airline. So the issue is to determine which legislative body has jurisdiction over the flight attendants terms and condition of employment. So when you look into section 9213, employment falls under provincial jurisdiction, but now the issue is when we talk about flight attendants, aviation and inter-provincial transportation comes into picture. So this is the subject matter of federal jurisdiction. Now we have to decide in our conclusion, in our analysis, which authority has main power to enact law related to terms and condition of employment of flight attendant. So given that flight attendants are integral to operation of airline which are involved in interprovincial international transportation, federal jurisdiction is applicable. So federal government can regulate the terms and condition. Section 91 federal power section does contain a basket clause. So in this basket clause, we have peace, order and good governance. So whatever matter is not assigned exclusively to provinces, we know that we bring that matter under section 91 POGG under federal part. But that does not necessarily provide an easy answer to the issue of regulation Because aerodromes, since the provincial power enumerated section 92, specifically include items such as property and civil matter, municipal institution, generally matter of local and private nature. So this is also basket clause. So issue as to which level of government control aeronautic was addressed in the case of aeronautic reference, which was decided way back in 1932. So while noting that some aspect of aeronautic could possibly fall under section 92, the Privy Council noted that mostly fell under headings of section 91, and that is why the remaining would be swept up by federal POGG power. So with this, we can conclude that Parliament has the authority to enact law related to terms and conditions of flight attendant as it falls under its jurisdiction over inter-provincial international transportation. Then we have pollution in marine water that lie within boundary of a province. So again, issue is similar. So here, what are the sections that comes into picture? So marine water, something related to navigation, shipping. So federal jurisdiction 9110. Then property and civil right, because pollution in marine water. And here boundaries of provinces are also in our question. So 9213, there is concurrent jurisdiction over works and undertaking when you look into 9210A, beyond the borders of one province. So these are the three sections that are there under rules that we have to analyze. So marine pollution within provincial boundary involve both federal and provincial concern. Federal jurisdiction over navigation shipping including pollution likely applies. However, there is a cooperation that needs to be there because here we are talking about something, a matter that is of federal nature, but it is coming under the boundaries of province. So cooperative federalism needs to be applied here. Then according to this greenhouse gas pollution, we know that this matter comes under the national concern, then peace, order, good governance topic. Then in R versus Crown Zellerbach, marine pollution satisfied national concern interest. Since marine pollution, because of its predominantly extra-provincial international character, is a clear matter of concern for whole of Canada. So the conclusion is both Parliament and provincial legislature may have a role in regulating pollution within provincial boundaries. So cooperation and coordination between both the governments may be required because this is a matter of national concern, but it is coming within the boundaries of a province. So there needs to be a cooperative federalism. Then regulation of legal profession, no doubt in this question because for this we have straightforward case of Kreger versus Law Society of Alberta in which it had been clear cut stated that provinces have authority to enact such law. So next is obligation set out in international treaties signed and ratified by Canada. For international treaties, we already discussed section 132. So foreign affair including negotiation implementation of international treaty, this is a federal power under section 132. Then if we talk about specifically international obligation, then we can also invoke peace, order, good governance because particularly this is not mentioned under any of the sections like 91, 92. So there are few cases like radio reference case in which we can clearly see that federal government could exercise their power of peace, order, good governance for the matters that are not explicitly mentioned in either of the sections 91, 92. Then for treaty powers related to international affairs, we have section 132. So for conclusion, it's very straightforward that Parliament alone has the authority to pass such laws. Then if there is any gap, that gap can be filled by gap branch of peace, order and good governance. Promotion and sale of insurance by bank. Now banking is a federal jurisdiction matter 9115 and insurance is a matter of provinces 9213. So for this directly we have important case of Canadian Western Bank versus Alberta which specifically talks about this thing. So whenever you have to see this kind of issue, just look into the core area, whether the core area which here is insurance falls under federal authority or under the provincial authority. So you have to look into these kind of thing, and then you have to see that if there are two distinct subject matter, two distinct laws on that, and they are not contradicting, they both can go at their own places, then there is no need to have any kind of interjurisdictional immunity, or there is no need to, follow the paramountcy or just interfere in the provincial matter. So let's look into the analysis. Banks fall under federal jurisdiction and their core activity, including promotion, selling insurance, are regulated by federal law. However, cooperation with provincial authorities may be necessary to comply with provincial insurance regulation. Now, in 2000, Alberta effected changes in Insurance Act, the effect of which was to make federally chartered banks subject to Alberta's provincial licensing scheme that was for the promotion of insurance products. Appellant Bank brought an application by declaring that their promotion of certain insurance products are authorized by Bank Act within the meaning of banking under Section 9115. Alberta Insurance Act regulation were constitutionally inapplicable to banks' promotion of insurance because of interjurisdictional immunity. Then Alberta's Insurance Act was inoperative by virtue of doctrine of federal paramountcy. So the trial judge dismissed the application, holding that the challenged provisions of Insurance Act were valid provincial legislature related to province property and civil right. He also found that doctrine of interjurisdictional immunity was inapplicable as there was no conflict between the two legislation. Court of Appeal also upheld this decision. So Parliament said that the banks should be allowed to enter into provincially regulated businesses like insurance by federal statute unilaterally broaden the scope of exclusive federal legislative power. The resolution of a case involving constitutionality of legislation in relation to division of power must begin with an analysis of pith and substance of the impugned legislation. The legislation whose pith and substance falls within jurisdiction of legislature that enacted it may, at least to a certain extent, affect matters beyond legislature jurisdiction without necessarily being unconstitutional. So the dominant purpose of legislation has to be seen. The pith and substance test usually look into the objective with which particular legislation has been enacted. So if some legislation has just incidental effect, that won't disturb the constitutionality. You have to go into the minute details of the objective of the act, that whether a particular act enacted by provincial authority is infringing upon the authority of federal government or not. So in certain circumstances, however, power of one level of government must be protected against intrusion, even incidental one. So here in this case, all the important doctrines were being discussed. First, interjurisdictional immunity, then federal paramountcy. So what was concluded? So it has been concluded that Parliament has the authority to regulate promotion and sale of insurance by bank as it falls within the federal jurisdiction of banking. Then retail sale of tobacco products to minor. So for this again we have direct case of Saskatchewan, Rothman, Benson and Hedges Incorporation versus Saskatchewan. So the regulation of trade and commerce, including sale of goods, is under federal jurisdiction. We know that while protection of health is under provincial jurisdiction. So the retail sale of tobacco product involve both trade and commerce and health. So both these areas. There may be concurrent jurisdiction, but protection of health is stronger provincial concern. So you have to look into the dominant purpose, the stronger concern, whether the concern is of federal government that is dominating in the issue or of provincial jurisdiction. So retail sale of tobacco product involve both trade and this we have already discussed. So in this case, federal law permitted display and advertisement of tobacco product except as authorized elsewhere. Saskatchewan, the provincial law banned display of cigarette in premises that admit person of less than 18 years. Supreme Court of Canada held that there was no frustration of federal purpose by Provincial Act. Provincial Act is also trying to save health of people of adult who are 18 years or less. Because a retailer could comply with both law by not displaying the tobacco product or by refusing to admit person less than 18 years. So here, on part of a retailer to do his or her business, if that person wants to follow the laws of federal government as well as provincial, there is no conflict here. So if there is no conflict, then you can follow both laws simultaneously. So this is what the conclusion says. Both parliament and provincial legislature may have a role in regulating retail sale. However, provinces may have primary authority due to their jurisdiction of health matter. Cooperation between federal and provincial authorities may be necessary. Simple. Then we have a long question, 15 marks, approximately 45 minutes. So this is about a bill, Bill C-22. Firstly, understand, whenever you get a question on a bill legislation, they are all hypothetical. You don't need to go into the intricacies. Whatever facts are saying, just go into that. Just make yourself understand that this is a hypothetical question and whatever the question is saying, that is true. You don't have to just judge any kind of legislation that how federal authority can make this or how provincial. Whatever question is saying, suppose, assume that is true and you have to analyze according to that only. So here, Bill C-22, currently before House of Commons, proposes to change the formula that determines. So this bill is trying to change means the topic here is amendment, number of seat in each province that will have in House of Commons. So basically amendment related to representation of few provinces in House of Commons. So this is the main issue. Try to conclude your issues side by side whenever you just read your question. So the existing formula set out in section 51 allocates seats based on representation by population, although exceptions are made to ensure that number of seats to which smaller provinces are entitled does not diminish over time. Because of these exceptions, if section 51 were not amended, the provinces with fastest growing population, these three provinces, would see their number of seats fall below the number they should have based solely on the basis of representation by population. So this is main area of concern. So here the issue of amendment is related to these three provinces. So I think the first thing should have been clear in your mind. Then this bill proposes to put in place a revised formula that will better reflect the principle of representation by population. If does this by altering the formula so that after the next decennial census the number of seats in BC Alberta would be increased so that their proportion of seat in House of Commons will match their proportion of Canadian population. Under this new bill's formula, Ontario's proportion of seat would increase as well, but that would be significantly less than the number of seats that they usually get or necessary as per the proportional representation. So you can see that there is a law, there is a bill. If that bill came into force, then there will be changes in the representation in the House of Commons number of people for these three provinces. So this is the main issue, simple issue. So now concern is that the federal government is taking the position that Bill C-22 can be enacted by Parliament alone without consent of any provincial legislature. Now, when provinces are involved, how can federal government make a decision on their own? Second is, number of members of opposition have argued that Bill C-22 cannot be enacted without approval of at least 7 provincial legislature. So here 750 formula, that is general amending procedure, that comes into question. What provisions in part 5 of constitution could be cited? So this is the question, this is the issue that examiner has asked. So we have to cite all the important sections. So issues are, firstly, what provisions of part 5 could be cited? Then in federal government's position, here you have to analyze based upon two different opposing view. So on one side, you will be saying that okay, federal government can justify as per this section. On the other hand, you can say that the opposition parties, the provinces, can justify their position by citing this section. Then in conclusion, you have to bring the correct position regarding which amending procedure has to be followed. So main issues, which provisions, what is the legally correct amending, we can make these first two issues into one as well. If you want to save your time, if you don't want to, go into complexities, then you can just make two issues. So for rules, all the important rules that you think you can add on, you have to mention here. Then in analysis, firstly, apply the rules to clarify federal government as well as opposition's position. So for federal government, they have as already mentioned in the facts that they want to enact this law without any consultation. So they may argue that they can enact law alone under section 44 as it pertains to number of seats in House of Commons, which is an aspect related to Senate and House of Commons. So section 44, here unanimity procedure, this one. So here federal parliament alone, section 44, allows the federal parliament to amend parts of the constitution related to executive government or Senate and House of Commons subject to section 41 and 42. So here federal parliament is bringing this section into picture. So you have to in your analysis mention this section first to justify federal government's position. Then you can refer to some case that is directly related to your justification. Then for opposition's position, they are saying that federal government cannot do so. Federal government has to bring into picture the consent of at least 7 provinces. So 750 formula we have here, general amending procedure, specific section, subsection that is related, you have to mention that. Just be clear. Don't write everything and anything that is mentioned in your notes. Just be specific so that examiner should understand that you know the actual fact, you know the actual section, actual provision. Then for the second issue, for legally correct position, you can mention the one section that you think is correct, and then you can justify that with your case law. And the conclusion has to be very crystal clear, crisp. It should clearly straight your attention. Whatever you think you want to bring into attention of the examiner, of the answer writing checker, just write that thing. Don't repeat things here. Like to conclude, and given the nature of Bill C-22, which involve changes, the legally correct amending procedure is this. So the answer writing checker is getting straight away answered that whatever you have mentioned above in your analysis under your rules, you are trying to bring all those things into one line. So you are clear in your mind. There is no confusion in your mind. Then next question, part 4, 30 marks. Again a bill. So this bill has not been passed and is currently before House of Commons. So this bill has been proposed to amend the changes in Canada's Election Act to require that voters reveal their faces before voting in person. So few religious communities thought that this is against their freedom of religion and conscience. Section 143 of Canada Election Act currently reads as follows. Each elector on arriving at polling station shall give his or her name, address to Deputy Returning Officer, poll clerk on request to a candidate or his or her representative. So they have to show their face. Then for proof of their identity and resident, one piece of identification, then two pieces of identification authorized by Chief Electoral Officer. Then how elector may prove us his or her identity, residence. So these are the other things. So these were the hypothetical provisions that were there in question. So an elector shall have an uncovered face. So this is the main issue. Whenever the elector is proving his or her identity, they have to show their face. So when few people oppose this thing, then the government has stated that the purpose is to safeguard the integrity of voting process by providing greater protection against voter fraud. So this is the intention behind the legislation. So you have to go by the harm principle and all those things. So Canadian Muslim Congress is upset about the impact of bill that will have on Muslim women who are Canadian citizens and have sincerely held religious beliefs. So sincere religious belief that require them to cover their faces in public. So CMC has contacted you, a renowned constitutional expert, to seek your views on this bill. They have asked you to assist them. So you have to help them as a constitutional expert, this Canadian Muslim Congress, this committee, this organization, so that they can put forth their issues before court of law. So here they have asked you to advise them on two issues. One is that Bill C6 violates Section 2A. What is Section 2A? Freedom of religion. Then 15, charter rights, equality rights. So you have to prepare a memo here. So here in note, the examiner have specifically mentioned that you don't need to address whether the bill violates the right to vote in section 3 of the charter. A different expert will address this. For exam purpose, you just have to refer to these two sections. So very simple, straightforward question. So firstly, whenever you're writing a memorandum, give it a heading, legal memorandum in capital words, then to the examiner from your name. Or if it is mentioned like senior associate, NCA candidate, then you can mention that thing. Or even if you write ABC, that would also work. Then date, whenever you are writing exam, mention that date. Then subject, or even you can write RE. So the subject is here is Constitutional Analysis of Bill C6, memo for the Canadian Muslim Congress. Then one important thing that students miss is introduction. Introduction is the most important thing whenever you are writing a legal memorandum. This is the requirement by LexisNexis as well, by legal research and writing protocol as well. So in legal memo, 100% you have to give a brief 3-4 lines introduction in which you will be stating the purpose of memo. So here purpose of this memo is to provide a constitutional analysis of Bill C6, which propose amendment to Canada Election Act and addressing this issue, requirement of voters to reveal their face. So now why you are writing this memo? Because Canadian Muslim Congress has asked your guidance on potential constitutional implications, particularly related to these two sections. So what are the issues? So primary issues to be addressed are whether the requirement to uncover one's face before voting as proposed by bill would violate the freedom of religion and equality right. So for this we have two rules. Rule 2A, then rule 15. Then you can just mention brief, like here we have one landmark case of R versus Big M Drug Mart. Then here we have R versus Oaks, in which we have 3-step test. So just give a brief. Then in analysis, firstly analyze freedom of religion. So the requirement to uncover one's face may be seen as conflicting with the religious belief of Muslim women who cover their face. CMC could argue that the proposed amendment, here why you are saying could argue, because they just need your advice and they will themselves argue before the court of law. So the proposed amendment disproportionately impact the specific religious group, creating infringement on the freedom of religion. Then you can mention any other important case here. The requirement of photograph was an infringement of claimant's sincerely held religious belief. So this case has exact similar facts. That is why this is 100% important for you to mention. So I would suggest whatever cases are mentioned in the syllabus, 99% the facts are from those only. So you don't miss on those cases. Those are like, you can refer to any additional cases to make your answer more elaborative, to make your analysis more stronger. But I would always suggest that whatever cases are there in syllabus, whenever you get a question on like equality rights, whatever case is mentioned under equality rights in syllabus, you cannot miss on that case. That is the first thing that you have to mention in your analysis. Then section 15, equality right. So discriminatory treatment, this could be the argument. So the government would need to establish a pressing and substantial objective like safeguarding the integrity of voting process. So here the burden is on government as well. So this charter right of equality here is subject to section 1 justification. So government has to go by that. But here this is not your burden of proof. This is government's burden of proof. That is why we are here not justifying section 1, because the examiner has directly asked you to just go to section 2A and 15. So here if you are going to analyze section 1 as well, then the examiner will get to know that you didn't get the requirement of question. So requirement here is not to prove the burden of government. Section 1, burden is on the government to justify their action. Here you are just justifying that how CMC's two rights are getting infringed. So then you can give conclusion. So whenever you're writing a legal memo, because they have asked you for an advice. So after giving your legal analysis, you have to recommend something. You have to give few suggestions. So these recommended actions, suggestions are always after conclusion towards the end. So these contain additional marks. So like here in this case, CMC should emphasize whenever they will be presenting these two issues before the court of law after your legal advice, the importance of religious freedom and equality. Then also consider proposing alternate measure that achieve the government's objective without infringing significantly on charter rights. Then collaboration with legal expert and human rights organization could strengthen the CMC's case in demonstrating potential constitutional violation. Okay, so now we are done with the sample paper that is there on NCA website. So now these are 100 marks questions, like there will be 4 questions, long and short, self-prepared by me, hypothetical questions for your IRAC practice. So again, like in previous questions, we have covered almost all areas from our syllabus. So here in these cases, I'll be again covering the whole syllabus. So first question, this is a fictional country of Federalia. The constitutional law is exactly similar to Canada. So akin to Canada's federal structure, operates under a constitution that is almost similar like Canadian constitution. That is why for this analysis we will be following the Canadian constitutional law provisions only. So the federal government here introduced a bill aiming to establish comprehensive environmental regulations. So the bill proposed uniform standard of emission, waste management, conservation effort, asserting federal authority over environmental matter. But the provincial governments, particularly those with significant natural resource industries, they are opposing this bill. They are saying that this is their local environmental policy. The subject matter of environment is under their exclusive jurisdiction. Federal government is saying that environment protection is a matter of national concern and it requires uniform standard throughout the nation. And they can enact this bill without the need of provincial consent. So here, what are the things that you have to analyze in your answer? Firstly, who has the part, whether federal government or provincial. Then you have to go to constitutional arguments and amending procedure, whether parliament can enact this bill without consenting from provincial authorities or not. So there are two main issues. Does or whether the federal government of Federalia have constitutional authority to enact bill? So under this you will have to see the division of power thing. Then what is the constitutional validity regarding amendment? So for this, the rules related to the matter at hand are follows. So these are the sections that you will have to include in your analysis. Then there are few important doctrines under rules. If you see some doctrine is applicable, then you can mention that also. Just give a brief 2-3 lines description of that. Then you can also mention landmark legal precedents for a better, stronger analysis of the matter at hand. So firstly, analyze the first issue, which is related to division of power. So in this scenario, the provincial government may argue that environmental regulation fall within their authority. In Federalia, like Canada, environment regulation can fall under various heads of power. So federal government may claim jurisdiction under different areas. Provincial government can also have jurisdiction under property, civil right, local work undertaking. But for the main clarity, we have to see the intent. So intent purpose is to address national environmental concern because it is specifically mentioned in the facts. So federal government can justify this authority under the peace, order, good governance power, particularly the national concern branch. Now, one mistake that students usually do is whenever you are covering any topic under peace, order, good governance, you don't need to go by all the three branches, emergency, gap, national. Just straight away mention out of those three branches under which your particular case is coming. So then you can mention this reference re Greenhouse Gas Pollution Pricing Act. Then for the second issue, you can directly go to the amending section, apply that, and then you can just mention the important one, case law. So then you can conclude in 2-3 lines. So I'm not going by the very details of these questions because you are required to write these questions on your own, then send back to me for checking. That is why I'm just giving you a brief idea so that you can easily solve these questions. But main analysis, everything will be depend upon your understanding of concept. Then there is second question. This is related to aboriginal right. So in a fictional indigenous land of Terraville, so this is no real indigenous community, a long-standing dispute between federal and indigenous community over treaty right. So the issue mentions here treaty right. Recently, federal government announced plans to develop a large-scale mining project on traditional indigenous land, which raised concern among these communities about potential violation of their treaty right. The affected indigenous nation argued that this project would infringe upon their treaty right to hunt, fish, gather resources on their ancestral treaties. So tensions remain high as indigenous leaders demand meaningful consultation. They want that the government should firstly consult with them. So as a legal intern, your supervising lawyer has requested you to write a detailed legal memo which include following issues. So your memo should analyze Terraville people's aboriginal treaty rights and duty to consult. So again, as previously discussed, legal memorandum, to, from, date, re, aboriginal treaty right and duty to consult in Terraville, very simple, crystal clear subject. Then introduction, what this memorandum addresses, talks about. So this memorandum addressed the constitutional framework governing indigenous treaty right in Terraville and federal government's duty to consult. Then the two issues, direct issues, then rules. So for rules, we know that we have to go by section 35 with reference to 25. Then for aboriginal rights, there are two important cases, R versus Sparrow, R versus Vanderpeet. Directly I'm mentioning here. And for duty to consult, we have a landmark case of Haida Nation. So no need to go into any other cases when you have such beautiful cases to directly solve these issues. Then analysis, firstly solve the aboriginal rights. Then for second issue, bring hibernation into picture, what meaningful consultation means, because here in the facts, so you have to modify your answer, you have to create a storyline as per the facts of the case. So facts directly say that the people are demanding meaningful consultation. So what does meaningful consultation mean? You have to analyze your legal memorandum. So this, then you have to conclude. Now, again, when someone is asking you to give advice on something in legal memo form, you are always suggested to give some recommendation suggestions at the end. So here again, after conclusion, you can see recommendation or suggestion. Then we have a short question, 20 marks. So in Canada, recent amendment to Freedom of Conscience Religion Act has sparkled significant controversy. So bill is C-2022. So this is related to imposition of restriction on wearing religious symbol in public institutions. So in response to this bill, several religious organizations, civil liberty group have launched constitutional challenge. They are arguing that this bill, this amendment is infringing upon their right under section 2A. So here directly in question it is mentioned that you have to go to section 2A. Also they have asked you to apply the framework in R versus Oak and this case. So when the examiner directly asks you to justify your statement as per section 1, then only you have to bring this R versus Oaks or section 1 Oaks test simply into picture. Otherwise, just go by your infringement. Justification is only required where it is asked by the question. So then here first key issue, then rule section 2A, then you are analyzing the amendment. And for this, since the question directly asks, so you have to modify the wording of your analysis as per that only. So in R versus Oaks, the Supreme Court of Canada established a framework for analyzing whether a limit on charter right is reasonable or demonstrably justified. Because here, when you look into the facts of the question, the question itself asks, apply the framework established in R versus Oak to analyze the amendment's objective proportionality necessity. So here the main thing that you have to analyze is as per Oak's test. So you will follow these 4 tests and you will apply it to the facts of the question. So you will see the primary objective of the bill. So to make analysis stronger, you can write these kind of catchy lines. It creates a good impression on answer writing checker. Let us apply Oak's test in a matter at hand related to freedom of religion under section 2A. Then you have to make rational connection, this case, then minimal impairment, syndicate Northcrest case, proportionality, Alberta Hutterian case. Because R versus Oak we already discussed and we already applied. So we did our whole analysis as per this test only. That is why there is no need to, separately mention this case, because we are already attempting the answer as per this case 4 test criteria only. Then at the end you can conclude, and if you are not sure, then you can add this line at the end that further judicial review would be necessary to assess whether this bill meets constitutional requirements or not. So examiner never judges on these kind of things. This creates a good impression. Then we have another case which is related to section 7. So here the issue is related to government's use of administrative segregation in correctional facilities like solitary confinement, which is against section 7, and for this fact we have a case law. So this hypothetical question comes from a case only that talks about life, liberty, security. So the main issue is, does the government of Liberta use of administrative segregation violate section 7, which protect life, liberty, security? So for rules, you have to just go to section 7 and then you can start your analysis. And for this, we have case of Brazil versus Canada, R versus Whistlesworth. So these are few additional things that I'm adding on here, because sometimes in notes the cases are those that are directly mentioned in syllabus. So I am adding these kind of things separately so that you can bring your attention here. So in R versus Wigglesworth case, then we have Everett versus Canada case, then Bedford versus Canada case. So these are all related to section 7, so you can mention and then you can give your conclusion. So yeah, this is the case upon which the facts of the question I have prepared. So based on this particular case. Since this is a short question, this is a like 10 marks question, that is why I am not, elaborating on what are arbitrary laws, what are overbroad laws, or what is grossly disproportionate. If you get this similar question in 30 marks, 40 marks, then there you have to elaborate all these things. Then even you have to go to this Bedford versus Canada important legislation as well, which explains all these things, what are arbitrary laws, what are overbroad laws. Then you can follow a complete detailed analysis. But in case you are getting a question straight away like this, just on one issue, one fact related to solitary confinement, section is directly mentioned, then there is no need to go by the detailed analysis. Just follow few 2-3 case law, relate the facts, and that's more than sufficient. So that was all about our course. So if you have any other queries, you are always more than welcome to text me on WhatsApp, or you can send me an email. Also, do follow Instagram page, Jurist Journey, NCA Triumph and Canadian Law. Keep supporting. All the best for examinations. Thank you and good luck.